Hey everybody, Greg Siskind here. I'm joined by Robby Rubin this evening, and I have not been here for a couple of weeks. I think this is the longest gap since we started this thing. I guess January of last year. But it's nice to be back. Next week I'm going to actually be on a ship, but I'm going to try and do the live stream while I'm on the ship. We'll see how good Elon Starlink is. I think that's who the ship is using for it. Robby, you and I had a very rare conversation a few minutes ago, talking about what we're going to be discussing tonight, which is that it was actually, as immigration goes, one of the quieter weeks we've had in a while. Not to say that there weren't bad things that happened. I mean, like, for example, TPS for Yemen was being yanked. I mean, there's the usual bad things, but and there were oral arguments in the H-1B case, and we're going to talk about that, and that's our case. So there's things to talk about, but I guess after Minnesota and after some of the things that we saw, it was last month. Yeah. It certainly seems a little quiet. Plus, we had a war that started that seems to have deflected a little attention. But there are, there seems to be a steady stream of courts that are ruling on immigration, and it seems like it's about probably 80% going against the administration in those rulings. So you could still find your a fair bit of immigration news. My favorite follow on X, which I'm still there, is Kyle Cheney. I recommend you folks that don't know him follow him. He's a reporter for Politico, but he has just been killing it as far as covering what federal judges have been doing across the country on immigration issues. He covers other things as well, but boy, if you look at his feed, you just see one after another of courts around the country that are making rulings, usually against ICE or usually against the DHS, regarding, you name it, on immigration issues. So there were still a fair amount of decisions that came up, and we're not going to go through a lot of them. There were a couple that were of note. One is I don't know if it was discussed last week regarding refugees that are being arrested and detained by ICE based on the argument that they haven't filed in a year for permanent residency, which is a total trap because you're not allowed to file before a year for permanent residency when you're a refugee or asylee. After your year is up, then you file, but they've never actually. Yes, you're supposed to file. In theory, you could be detained. After that point, you're sort of in a but even then, that's basically normally just a check-in that they have to determine whether you still are entitled to refugee or asylee status. It's not to say that you're violating any laws or anything when you don't file for permanent residency that quickly. In any case, the courts aren't too happy about that. I think I sent you a Minnesota. It seems like right now they're mainly just applying this in Minnesota. But there was a case from a couple days ago, Judge John Tunheim's court in Minnesota, where the judge basically said that the government had no power to issue detentions and arrests for refugees who haven't otherwise violated any laws. So it's a shame that needs to be said on there. But and these are people that are completely law-abiding and who have been vetted sometimes for several years before they're allowed to come into the United States. All right, there you go. Okay. It's spring. Spring is here in Memphis. It's about 75 degrees out right now. Okay, so that that was probably, as far as court decisions go, on detention issues. There's also a detention case in California where the court is basically the Ninth Circuit's going to review a district court's determination that bond has to be a bond must be an option for people that are detained in immigration. The Trump administration was trying to detain people that are in removal proceedings without giving them the opportunity to bond out. And obviously, if it takes 10 years or 12 years to get your day in court because the courts are so backlogged, and they won't give you a bond to allow you to wait it out outside and to work, it's gonna if they want to push people out of the country to self-deport, that's going to do it, and that's why it's kind of a critical thing. It's like these are people who are in removal proceedings, but they are not necessarily they shouldn't necessarily be removed. They may have a legitimate defense to removal, and they may and not allowing them to have a bond hearing is essentially giving them a 10-year jail sentence if they don't. So I hope that the courts kind of like look at the reality of what that determination means. They try and just say it's a civil holding and it's not actually jail, but it's jail. If you're detained someplace where you cannot leave, you are imprisoned on there, and it doesn't say. I don't think it matters whether it's just because you're not being charged with a crime. The fact that you're being held someplace against your will is jail. Okay, so we had that piece of news. There's H-1B news, and I think Robby, that's probably
there was also in terms of just the court. There was we don't really do a ton of this work, but it's a very, very big piece of news in the immigration world is the kind of deference now from a Supreme Court ruling that goes towards BIA, trying to overturn a lower court decision in a BIA.
So you're talking about the 9-0 decision that came out today from the Supreme Court?
Or was it earlier? I thought it was earlier. I don't know if it was today. Was it earlier this week?
Well, there was a case that came out, Arias Orellana versus Bondi. No, that was this morning, and it is that one was the court ruled unanimously that that they have to use a quote unquote relatively deferential standard when reviewing BIA decisions regarding whether somebody who's sought asylum in the past, whether their past experience constitutes persecution. In other words, basically not second guessing the BIA's determination about whether a person's been persecuted or not. I'm a little surprised it was 9-0, but I guess that's the assumption is that the BIA is acting in good faith. I think we're seeing some evidence of late that the BIA is being heavily controlled by the White House, especially what we're seeing lately regarding a mandate that they almost automatically deny everything that's coming there, and it seems like there's a lot of influence coming from senior ups in the administration regarding how the BIA acts. So I'm not sure why a federal judge can't take a look at the actual facts and see whether whether the BIA is really acting in good faith or not and doing their jobs. But we shall see. By the way, I've been working on this project we're going to, I've hinted at it, but we're going to have all of the unpublished BIA decisions in our AI product in the they're there. They're sitting right now. They're not in the model that anybody can use. They're in our staging environment. We're testing them to see what's the best way to incorporate them into answers, and we may just leave them separate, where you just basically have to include them. But that's not the discussion for right now. All right, so that was the Supreme Court, issued that decision today. It is the Supreme Court doesn't do usually more than a handful of immigration decisions a year. The next one I think that we're going to be seeing is birthright citizenship. I think the oral arguments are coming up early next month, and that will be essentially the blue state attorneys general arguing that case. So I don't think it's going to be a 9-0, but I still am fairly optimistic that it's going to be something like a 7-2 decision. It's not going to be super close. I think the best argument that I think I've heard on the birthright citizenship is there was a Georgetown University law school study about, at the time the 14th Amendment was passed to the Constitution, there were, if you interpret it the way the Trump administration is suggesting that the amendment should be read, there would have been a number of sitting congressmen, and they're all men, the sitting congressmen who would have potentially not been eligible based on their citizenship if you didn't read the 14th Amendment the way that was said. And so it was sort of like, and the fact that no one raised any objections or made an argument that somehow now, with this 14th Amendment would have an impact on these sitting congressmen, is a pretty good indication that no one was reading it the way it's being read. So anyway, that's coming up. Let's talk about H-1Bs now, though. So last week, the day after this live stream, Global Nurse Force is the California H-1B case, and I'm a lawyer in that case, as well as a couple of dozen other attorneys that are with different organizations that are part of that case. And we had our arguments in front of a judge after a long wait. And I am cautiously optimistic about the way it went. I just got the transcript today and decided to do another perusal of it. And basically it seemed, the broad issue, the big thing that's interesting right now in this case is, the chamber didn't win its case at the district court level in DC with Judge Howell. And that was obviously going to be an issue that was going to be raised. And the judge did indeed ask why our case is different, or whether the judge was wrong or our case is different. And we had some pretty good responses for that. Different kinds of plaintiffs, some different arguments. But really the biggest difference in the case is something that happened after that decision, which was the Supreme Court decision on the tariffs and learning resources is the name of that case from a couple weeks ago. And that's the one where the Supreme Court ruled 6-3 that President Trump's tariffs are a tax, and only Congress can authorize a tax. Congress Congress could have given the president the power to do that, and they didn't. So we are, our strongest argument, I think, in this case, and the judge spent a lot of time asking questions about it, is whether whether this $100,000 H-1B fee is in fact a tax, and if it's a tax, did Congress authorize the president as part of Section 212F? This is the basis for the travel bans. Can a tax be included as a form of restriction that the president can place on admission? And I have to be honest. First of all, I went back and I did a dive today actually into 212F's legislative history. Um, and there's not any discussion on that issue. It seems like they didn't even contemplate that as a possibility. Congress when they were looking at that. So it is it's but I can there are some good arguments that were made by Esther Sung and by Cynthia Lau and who were arguing the case for our side. That there's some good cases and there's some good arguments that uh, Congress authorized the president to restrict entry, um, and that's it. The president can say, can close the door to entering the country, but he can't change other aspects of the immigration system, including fees. And to charge $100,000 to get around it is a tax. Now, one thing that was interesting um, that we didn't learn until our hearing was actually how many people have paid the fee. How many employers, I should say, that have paid the fee. And the judge asked that, and they got an answer, which is 70.
Oh my gosh, it's almost nothing.
No. And so that actually became an argument for the government saying it's not really a tax because it's like not really raising very much money. And, it's sort of like, I mean, come on, on there. That's like saying that if you want to raise less money, then all you have to do is say the tax is $1 million instead of $100,000 on there, because then no one will pay it at all. They'll just go for a gold card, I guess, or whatever. But it's just the reason why so few people are paying it is because it's so high, and there are certain employers, and a lot of them are plaintiffs in our suit, as examples, that are employing school teachers and nurses and others, where it would just not make any economic sense whatsoever to pay, what may turn out to be, a teacher in South Dakota on an Indian reservation is probably making $50,000 on there. So, of course, they're not going to pay $100,000 filing fee for that. That's just ridiculous. It's cheaper to send the kid on ship the kid on an airplane and live for a year in New York City and pay for their private school tuition than it would be for a school system to pay that kind of money. So that was so the arguments, I think, went pretty well overall.
Did the court or the government bring up the Chambers case at all?
They did, and they wanted to know some of the differences about it. So and I think we argued that the judge, at least on the tax on the $100,000 fee, that she sort of just reflexively said that it's a restriction, and the president can put any kind of restriction that they want on entry, including paying a fee, even though that is not at all clear from 212F that is in fact permitted.
In Chambers, did they bring up the APA issue in Chambers because of the president? Like, that's not something that would have to go through rulemaking?
Yeah, so that came up in ours. I don't know if it came up in the Chambers case. It's been a couple of months since that got argued. But we did argue. I mean, our strong APA argument we had as well is that it's one thing to block the entry of an individual or a group of individuals, but it is another to just dismantle whole sections of the Immigration Act because you don't like the H-1B program. And when I was looking through the legislative history today, I think what was interesting is originally they were looking at this as just something that there were provisions in wartime that the president could use to block entry for people And this was being, this is 1952 we're talking about. And it was largely about communists and trying to keep out people that they were considered subversive. And actually, a lot of it was about um, Eastern European Holocaust survivors who were sitting in refugee camps in Europe, and a lot of them had backgrounds in left-wing politics. And there was a lot of talk about making it a lot easier for the president to just cherry pick out different individuals that they didn't want to allow in, and that's what 212F was about. But in the legislative history, there is some language. There is language about, for example, believe it or not, about what to do if there's a pandemic.
Mhm.
And I was a little surprised that they were thinking about it that far, that many years ahead, because of course 212F was used heavily during COVID by both President Trump and President Biden. And it looked, so that was interesting that was there. And it was also, there was some language about like what happens if there's a massive spike in unemployment in the United States. Could the president use it there? And it seemed like Congress okayed for that. But even there, it's not actually dismantling of visa categories and all that. It's just a temporary block until whatever problem in the economy is solved. I should note, when the president did this, we were basically at, near record unemployment, near record employment in the U.S. as far as the record low unemployment, I should say, when he did this. So there's not much, and they did give a little evidence that from biased sources that about the IT industry and H-1Bs, but as we know, most of our plaintiffs aren't in IT and in global nurse force, and in those cases, we're talking about near zero unemployment rates in some of those categories, particularly for doctors, for nurses, and some of the others. But did they contemplate a tax? No, and nothing that never comes up in any of the legislative history that I was able to identify on there. And they were even talking about in the legislative history about visa issuance being something that, and processing being left alone, which is a big part of what we're arguing, is that the only thing that that can be done in these cases is to restrict entry temporarily, and everything else that they're doing. And this comes up in our other case, the 39 country ban case, that's with the benefits pause, that benefits themselves are not covered, that are being issued by USCIS. Visas that are being blocked from being issued are not covered by 212F. So we argued ultra-virus. We made the ultra-virus argument, which is that the president is essentially undoing major sections of the Immigration Act, which Congress passed, and that's not what he was authorized to do. And we'll see how the judge reacts to that. A couple of other items of news related to that. I believe on March 9th, there's additional arguments that are scheduled for the motion to dismiss from the government. There is also in the next couple of days a brief that is that each side has to provide the judge regarding the applicability of that Supreme Court case, Learning Resources. So the judge is going to get more information. I've gotten some early looks at the drafting on that. I think the arguments are pretty strong on our side. So that'll be a couple of days from now. Everybody will have an opportunity to read that. So it's and we did actually get a question about the case from Rachel. She said, I know it's hard to speculate, but do you think the ruling on the H-1B case is going to be on the basis on constitutionality of the tax or the APA claim? How the ruling look like? So we don't have a ruling yet, but Rachel, I do think that those are, the crux of the case. The tax is actually a constitutional argument. The Congress actually is empowered in the Constitution to with the taxing power, and they have to and to the extent that the president sets a tax, it has to be something that's delegated. And we made the arguments that Congress did not delegate anything having to do with taxes as part of the 212F policy, and indeed, it's never been used as there's never been a tax that's been imposed previously. Of course, the government argued that, well, they never used it for a Muslim ban either, until that happened, and that's true. But they in this particular case, the Muslim ban was a ban on entry. That's all that, and which is what 212F is about. Whereas the $100,000 fee is a tax, and the question is, can you couple that with an entry ban? And I think the argument is fairly strong. Even if you say that the H-1B ban is something that could be upheld, the $100,000 fee part of it is not. The other thing, Robby, there was an interesting article in Law 360 that just came out a couple of days ago, and it kind of confirms what we already know. And we told the judge this in our case, that the national interest exceptions are a sham. I don't know what else you call it. All these lots and lots of people have filed national interest exceptions, and not a single national interest exemption has been approved in the entire country.
And are these for the exemptions from the $100,000 fee, or exemptions from the benefits pause?
No, I'm talking about the $100,000 fee. That's a separate issue. The benefits pause is not actually a travel ban.
Right.
I don't know if they've issued national interest exceptions for people that are just seeking entry.
This would be like for people that are here, that are like, that have,
they have suggested in the memo that somebody could get around the benefits exception and the benefits pause by making national interest arguments,
right,
which is not helpful to them, because they're trying to say it's not a travel ban, and it's not 212F. It's just further vetting that we're doing, because the president has indicated that that it's sort of bootstrapping, where they're saying that because there's a travel ban, then we need to vet these people more, because there's something suspicious because there's a travel ban, and it's we'll get to that in a second. But on the H-1B, the national interest exceptions, there haven't been any that have been granted, and interestingly, in these cases, the government's arguing that the arguments that we're making are all the plaintiffs should have to demonstrate that they attempted to get a national interest exception before their argument should be heard. So it's kind of a joke that it's that they're not even adjudicating them on there. They're just sitting on them. So it's not like they're actually that they're considering the facts and making decisions saying yes or no that you have national interest. They're not even like looking at the issue on there. So it's almost like they're forcing people to basically have to pay the tax, as opposed to getting a waiver of the tax through that exception. Honestly, I know there are a number of people who have filed for those. It's 6 months almost since you filed those applications. It's time to file mandamus claims, folks. Don't if you're sitting there and you're waiting on these cases to get decided, there's no evidence that that's going to happen. They still, as far as we know, have gotten no guidance on how to actually issue determinations there, and it's because they don't have any intention to issue guidance. They know how to do this. It's like they've done dozens of travel bans previously, and they had national interest exceptions in there, so they know how to do this. This administration in particular, they're the ones who basically invented the travel ban, because no one used it before Trump came into office. There were probably maybe like 2 or 3 dozen people in the last 70 years, or almost 75 years since this law passed, that got that got banned. So the whole way this operates is all basically creation of the courts and the creation of the administration. Okay, so that was the H-1B case. We also had so there was some positive news in the benefits pause cases, which we were just talking about, Robbie, and you were asking about national interest exceptions. There was I know Tony Drago in Boston, a great lawyer, had a win in that court on a benefits pause for some of his clients. I think Curtis Morrison has a case also that has had some had a ruling on, I think it was on EADs, that the USCIS had to proceed with them. So already we have some judges basically saying that the benefits pause is illegal on there, and you can't use 212F to justify it. We have our own case that's been filed in Atlanta. I don't know how many plaintiffs off the top of my head, but we have a couple hundred plaintiffs in that case. And then we have a separate case in Boston that's challenging the visa ban. And I feel pretty good about both of those cases because neither one of them, they're both relying on Section 212F for things that are not entry bans. And, in the case of the visas, we have our own cases from the first Trump administration and early Biden administration, where we won a string of cases just on this very issue about whether 212F allows the administration to stop issuing visas. That's going to be a problem for them as well with the 75 country immigrant visa pause that's going on as well. In that one, they don't even cite 212F. They don't cite anything. They just say that, that I think they are
Public charge.
They're wanting to look more closely at the public charge, but there's not any new regulations. There's not anything new in that space. There's no legislation, and to just basically halt for half the countries in the world, or whatever the number. I don't know how many countries are in the world. It seems like that's about half the countries. That's I don't think that's going to last very long once the judge gets a closer look at that. So look for movement. We just had last Friday our latest filing in the in our case in Atlanta on the benefits pause, and we should be hearing something fairly soon from a judge. So we're going to we'll have more news on that soon. But that's that I feel pretty good about that case, and I feel pretty good about the visa ban case that are tied to the 39 country bans. We can't get, you really can't get rid of very easily the country bans. The 212F cases, that the president gets a lot of deference on that. But you, at least for people that are in the United States right now, you can't claim 212. You can't claim the bans and extend the bans to people that are actually physically in the United States. You can only keep people outside the United States from coming in with that ban, and you can't bar them from getting a visa either. So the idea is this is supposed to be temporary. This is not supposed to be permanent, and it's supposed to be reviewed very frequently. And a lot of it's about vetting, just to make sure that the individual, you've had more time to check them out and make sure everything's okay on there. But it's not supposed to basically be a ban for the entire presidency, which is we know it's going to turn out to be if the courts allow for that. All right, Robbie, what else do we have on the list of issues we wanted to talk about? I'm not sure that we have much more.
Yeah, there was some more. We talked about the TPS ending for Yemen. There was a lot. We had some news regarding more humanitarian side of immigration law.
Well, the Yemen is it's a basically what they're doing is they are saying as these TPS programs expire on their own, that they're just not going to renew them. But courts have been saying you can't end the programs just because they're expiring without demonstrating that country conditions have returned to normal. I don't know about you, but would you feel safe going to Yemen right now, or Saudi Arabia, or Qatar or the UAE or Oman or Turkey or Israel or Jordan or Iraq, any of those countries. I mean, it's a little ironic that they're this makes news on March 2nd, and this is already after this new war started. On there, I am pretty sure. Well, almost every one of these TPS countries have gotten litigated, um, and the cases are usually coming down to initially they come down to whether an injunction, is to stay in place and whether work authorizations are to continue on. There's usually a fight over that, and that's gone back and forth on there. But there are, to the extent when we're starting to get decisions on these things, it's usually coming down to the actual facts of whether the administration has, arbitrarily removed a designation without, when the facts suggest that the country conditions are actually worse in many cases than they were when the designation was issued in the first place. And you can't get rid of TPS unless you can show in good faith that
I think
it's
the one before Yemen. I don't remember which country. Was it maybe Haiti? That they tried, that it was just litigated, and the judge in that case was just like, it was just very clear. Like she didn't even really have to get into the merits of it because the government just almost like,
it was Haiti. They were ready. They were lined up. They had troops basically, ICE troops lined up outside of Springfield, Ohio, the town that with the dogs or the cats. I mean, it was on there. I'm just like, almost funny to still think about how stupid that whole thing was. But they were ready to go, and that was going to happen until a judge put a stop to it. But
because in that case, they didn't even get to the merits of the country conditions in Haiti. I think the judge's main point was, you guys, the government didn't even like do the very most bare minimum, like fact find. Like, they didn't engage in any of the processes that they're supposed to. Like,
yeah, they probably just called the Trump appointed ambassador to Haiti, and it's like, how's it going down there? Oh, it's great. Okay.
Yeah. So I think the government's just like being, I think, a little arrogant, maybe, I guess, and just not even really trying to like follow the rules, where if they I mean, I don't know about Haiti, but I'm sure there are some countries where there's a colorable argument, at least in terms of country conditions, that they can make, but they're not even attempting to go about doing it by the right process.
There are. I mean, I would think that sometimes there are countries that are, the basis for continuing it is that a lot of the people here are providing remittances back to the home country, and even if they could go back, the country is such a basket case that they need to be able to send money back to their families back home. And it may be 20 years. I think you can make a better argument probably in those kind of cases if you can document that the countries really, the conditions really haven't changed or have changed, or there's like a natural disaster in a place like Nepal, for example, which had the earthquake. I don't know how many years ago that was, 5 or 6 years ago. And in that case, I mean, I don't know, honestly, about whether the infrastructure, everything has been rebuilt to the point where it's largely recovered from what it was. But that's how you would document it. So you would go out and get government reports. You would get human rights reports. You would get essentially, have documentation about whether the destruction that took place, whether they, essentially remedied as much as possible or to put people's lives back to normal. But you're right, they're not doing squat in any of these countries. So, they basically, we've seen this over and over again with the administration, especially when it comes to court on there, is that they're not even doing the basics to convince judges on here. I think they're just in a lot of cases just knowing, and they're announcing policies knowing that it's likely a judge is going to throw it out, and then basically every once in a while they get lucky because the judge that's drawn is somebody that is maybe um, a little bit more open-minded to some of their crazy arguments than others. But I don't know how you explain it. And I also don't know how the DOJ lawyers like just get up every day and argue this stuff when they know what the law is, and they just know that, and I don't know if they're arguing good faith or not. Maybe they're true believers, or maybe they feel like, I'm being paid to make these arguments. I'm going to make these arguments, but it seems like one of the worst jobs in law right now is to be a DOJ lawyer that has to actually defend administration policies on immigration, because you're going to get railed by the judge. You're going to be making arguments that you don't believe in. At some point, they're going to get bar complaints. Some of them for some of the ways that they're arguing. Their clients are not cooperating with them. ICE is not giving them the data, and they have, a lot of times they're going into court and being chewed out, and they don't have anything to tell the judge about why deadlines and things like that are being missed. It just seems like a miserable existence, and it's a probably, that if there's any reason why they need that no bond thing, it's because they have a real shortage of lawyers, that because so many people have quit the Justice Department because it's such a miserable job on there. So, yeah, I mean, I think I'd seen the figure now. It's like 20,000 habeas cases have been filed. And those all have to be, and those aren't easy cases, and they all have to be, I've heard like of DOJ lawyers who have like 50 or more of these habeas cases that they have to deal with on there. It sucks, that job.
Yeah.
And anyway, I think that's what that DOJ lawyer actually told the judge, that her job, that she wanted to be held in contempt just so she can get some sleep.
I remember that.
So anyway, you could quit. That's the thing. I didn't feel that much sympathy for this person, because it's like, you could quit. And actually, if you quit and you put on your resume, I quit in protest, on there, you probably would find a job just by saying you quit. You quit because you couldn't do the job. Felt like you can do the job ethically, but that's not what's happening. So there you go. All right, Robby, I think we've covered most of the ones I want to talk about. I don't know. Is there anything else you want to talk about?
I think I mean,
you mentioned the lottery started this week, today.
Yeah.
Why do we tell people who enter the lottery? May the lottery gods be with you.
Yeah.
May everybody get chosen.
Yeah. Hey, this year there could, applications could be down with the $100,000 fee, taking out a lot of potential the pool of applicants, but
they'll be down. And hopefully, if you apply, this is the year to apply. You might actually have a better shot this year than a long time.
Yeah.
In terms of getting selected. So good luck. Today's day one. We got 2 weeks of the lottery. If you're listening to this and you're, and you have an employer that has been on the fence, my recommendation is go for it. It's only a couple $100 to file a lottery entry. There's a lot of reasons to believe that there will be changes to the H-1B program thanks to the courts. So I'd go for it if you have the option.
Agree.
And there you go. All right. Well, I'm going to end tonight, Robby, and I thank you for joining tonight. Thanks everybody else, and we'll be back next week. And maybe we'll have some good news next week. It wasn't all bad. Well, it was mostly bad this week, but it was not as down as it usually is. But hopefully next week we'll have something positive to report. Like maybe some news on the H-1B case that'll be positive. We'll see on that, or on the 39 country ban case. So let's see. Keep our fingers crossed that we'll get some good news between now and next Wednesday night.
Sounds like a plan.
All right.
All right.
Bye, everybody.